if ChatGPT or AI creates the program or the manual and writes it itself, can it be protected by copyright laws? Hi there, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Corey Sterling. That's me. Thanks so much for joining this week. We're going to jump into a very, very, very relevant topic, which is AI and copyright laws. And I know that everyone just wants to talk about AI all of the time. I try not to focus on it too much, but where it is completely, totally relevant as it relates to law for health and wellness professionals, I have to do it. So we're doing it now. As always, my intention in creating this podcast and taking the time to record it is to provide practical, easy, and light legal information for health and wellness professionals so that they can properly protect and grow their health and wellness businesses. Some episodes are a solo episode where I talk about legal issues. Sometimes I have episodes where I bring on a guest who's an expert in one area of the health and wellness field. And this is a solo episode. So, AI and copyright laws, still undetermined, still unclear about what all of the rules are, but I did go through a very, very interesting situation with one of my clients last week, and I think that it merits talking about and sharing the story so that everyone understands. The legal question here and now is whether or not copyright, so let's say in this context we're talking about words and a particular fitness program that was created for one of our clients, whether or not if ChatGPT or AI creates the program or the manual and writes it itself, can it be protected by copyright laws? That's a really, really big question. And the reason why the implications are so serious is because if it's not protected, then anyone can copy it, anyone can reuse it, anyone can take it and do whatever they want with it. And as you'll learn in the story that I'm going to tell you about my client, this can have very, very serious implications into what we can protect, what we can sell, how we can control it, and how we can maneuver the laws around it. So while this issue is unresolved, there has not been a ruling in North America or in a case, but the general idea is the belief that copyright can only apply to something created by a human being. So copyright is protection in an artistic work. So copyright can be protection in a photograph, it can be protection in a song or music, and it can be copyright for an artistic performance like a dance, and copyright can also apply to written words or programs. So for us in the health and wellness industry, this relates to programs that we create, if we offer teacher trainings, if we're industry leaders in that area, and we get a staff member, we're like, okay, just use ChatGPT and come up with a new type of program that we're going to use. Now, the issue is if that is created and written by AI, and it's not written by an individual, it may not be able to be protected under copyright laws. And if it cannot be protected under copyright laws, it means that you lose the ability to control who uses it, how they use it, and what purposes they use it, and if they go and resell it off to someone else. So normally how it works at law and copyright is you have a teacher training program or you have some sort of program that you create that's unique to your business. You were the one who created it. What comes to mind is one of my clients has built a Pilates academy, and I'm going to have him on the podcast in a couple of weeks. And he sat and wrote everything, all the positions, all of the benefits, everything. It's like he wrote all of it, 100%. That's his copyright. But also, he could have just gone into Claude or ChatGPT or Gemini or whatever and say like, hey, make me a Pilates training program for using a Cadillac Pilates training program as an example. And okay, that can be done. That can be created. There's no issue around that. And then if he sells that program to people or he's doing a master teacher training or whatever it is that he's doing, if he doesn't have legal ownership in the copyright, he can't enforce the rules around it. So that means someone can take the materials and then use AI to build a website in 3 hours and build a marketing funnel in 2 hours and sell the exact same program. And because there's no copyright that applies to it, they may lose the legal rights. They have no legal rights. It's still unclear. So the story that I went through with one of my clients was just this. They had a teacher training. The materials they created from the teacher training were created by AI. It wasn't created by them. There was a part of it that they used AI to create all of it, a new part of the training. They charged money. They had people come to their studio and they did the training, and they found out that someone broke the rules of the teacher training agreement, which said you're not allowed to use these materials in this particular way, this, that, or the other. The response that we got from the other person was, well, I know that these materials were created by AI because I spoke with someone who was part of creating them. Therefore, you have no copyright over them. Therefore, because you don't have any legal right or claim to the copyright in these words, you can't enforce your rights on this. It's not enforceable because it wasn't created by a human. And so for me, as a lawyer, I'm in a difficult position because A, there is currently uncertainty around this. And B, I'm trying to support my client as best as possible, but also I have to play with the cards that I receive, that I'm dealt. So I'm advising my client. I'm like, okay, well, can you show that someone actually made this and someone created it? And they're like, no, actually, we used AI for this particular portion. And I was like, okay, well, then in this case, it would be very, very difficult to have enforceable rights around it. So why am I talking about this? A, because everyone should know that when you're using AI in 2026, right now, the legislation has not caught up to how society behaves. So I saw this happen in COVID as well, where in COVID, a lot of the things that how health and wellness businesses operated were changing very, very quickly with online classes and online studios and all of these things. But the laws didn't have time to catch up because it has to get passed through a legislative process, and you have to wait for a case to get in front of a judge so that a judge can make a ruling. And even when the judge makes a ruling, it's going to get appealed, and then it just goes on and on. So until we have a formal ruling of law, right now, the general understanding is if it's not created by a human being, it can't be protected by copyright. That may change in the future, but what I want you to know here is that it's really important that you understand that there are unclear ramifications of using AI. And it's not intuitive. It's not something that you would think, right? Unless you really studied law or you were really as interested in these things as I am, you wouldn't probably think about these things. But that doesn't mean that they're not legal issues. The other thing is, what is the remedy? So what can we do until there is a clear pronunciation of the law and we really have a lot of clarity around the issue? And the answer is contractual law. And even though we may not be able to assert copyright into something, we certainly can put in contractual provisions to say, okay, maybe we're not enforcing intellectual property laws around copyright for this specific issue, but we can come up with other contractual provisions that say, hey, if we're allowing you in this program, you agree that all the information that you receive is confidential and you will not use it or share it with a third party. Right? Then the question isn't copyright. The question was, is this a promise that was made in contractual law? And to me, it's just fascinating because this is how the law evolves over time. For me, I've been a lawyer in health and wellness now for 9 years, coming on 10 years, and I've seen a lot of changes take place. And it's interesting because this is another example of a change that's taking place in real time. The most important thing is that you are updating your agreements to reflect how your business operates. And I'm not going to tell anyone that they shouldn't use AI in making materials. I think A, if you're doing it, keep your eyes open. But B, you have to make sure that legally you're following all of the appropriate steps when you do that. And there are new solutions to using AI as part of your business, but you need to be aware of them and you need to be proactive with them. So in summary, in this week's episode, I'm talking about AI as it relates to copyright and the legal question that if a work is created not by a human being, is it eligible to be protected by copyright? The answer currently, I believe, is no. We're waiting for some form of judicial ruling on this so that we know. But more importantly, the question is, as a health and wellness business owner, what are the things that you can do to protect the parts of your business you are using AI? And the answer is to update your contract. So that's part of the reason why we created Conscious Counsel Plus, which is a membership. We edit and revise all of your agreements. The cost is $308 a month. It's a 12-month commitment. As your business changes and you include new parts, it makes perfect sense to have a legal team who understands the changing landscape to support you. So you can just find us on Instagram at Conscious Counsel and shoot us a note, and we'll be happy to have a consultation with you and share more information about our membership and other services we offer. I hope that you enjoyed this episode, and whatever it is that you do, make sure you work with a lawyer who loves you. Peace.